So I wasn't actually planning to make a follow-up video on the amicus brief filed on Tuesday by the ERA, CLWC, and CELA. It seems uncommon to reply directly to amicus briefs because they do not require any action or consideration from the judge. However, Bryan Freedman has very quickly submitted an opposition to the letter motion to even submit the brief. And I'll analyze and discuss his argument in a bit, but this is another example of how Bryan Freedman and, by extension, Baldoni are literally fighting to shut down AB 933 by trying to block its drafters and advocates from defending its invocation in this suit. Nearly every argument made by Freedman in this letter is easy to argue against or debunk, and that's because his filings since the first lawsuit against the New York Times use very manipulative language in order to imply something other than what he is actually saying. The very first footnote of this letter says that Your Honor's individual practices in civil cases does not include motions for leave to file an amicus brief as a motion type permissible by letter motion. And to break this sentence down simply, very simply, he's saying that Lyman does not permit motions for leave to file, not that they do not permit amicus briefs at all. That's why I wanted to analyze it in detail and break it down in easier to understand terms for those who might be easily fooled. So, on what grounds is Bryan Freedman arguing that this amicus brief should not be allowed? First, he claims that this is a PR stunt designed to attack the Wayfarer parties publicly. Next, he states the brief comes from partisan, meaning biased in this case, groups, and does not satisfy the limited conditions under which a district court may consider an amicus brief. I'll outline those later. He also claims they make arguments irrelevant to Lively's motion to dismiss. Finally, he argues that they submitted the brief too late. He first states the organizations who filed the brief are making unwarranted attacks on the Wayfarer parties with inflammatory comments to the press. The motion serves as a publicity stunt. He accuses the ERA, CWLC, and CELA of attempting to provide disguised, premature, and inappropriate expert testimony, while only interested in supporting Blake Lively, as the vast majority of amicus curiae briefs are filed by allies of litigants and duplicate the arguments made in the litigants' briefs. This is demeaning and insulting to the organizations who very clearly explained in the amicus brief that they are advocating for all victims of sexual harassment, assault, and discrimination, including but not limited to just Blake Lively. It's also ironic since Freedman himself has enacted publicity stunts using legal filings. The most recent example was his subpoena of Taylor Swift and an accusation made against Lively's attorney in a letter to the judge. The accusation was so egregious that the judge has already struck his letter from the court record, along with his affidavit in which he claims he heard it from someone who heard from someone that it's true. So it's a bit hypocritical to deny this motion to submit an amicus brief on these grounds. But beyond that, he makes no actual reasonable arguments that show these organizations have any personal connection to Lively. And he later on mentions arguments that were not brought up in Lively's motion to dismiss Baldoni's defamation lawsuit, thereby proving himself that these are not simply duplicated arguments from friends of the litigants. To further his claim that the amicus brief is biased, he says they are advocates of specific policy interests that align with Lively's affirmative claims against the Wayfarer parties, meaning that they cannot be neutral. This weaponizes a false understanding of neutrality that ignores that a lawsuit has two opposing sides and arguments are made to support one side or the other. The amici are neutral in the sense that they are unaffiliated with Blake Lively and Justin Baldoni personally, but amicus briefs are often submitted by parties with strong interests in the outcome of litigation. Let's take a step back to analyze what Freedman means by advocates of specific policy interests that align with Lively's affirmative claims. Lively's claims are that she was sexually harassed by Justin Baldoni and others. These advocates' interests align with that in so much as they are advocates to victims of sexual harassment. So, to put it plainly, the ERA are advocating for a policy that protects the rights of survivors of sexual harassment, assault, and discrimination, including Blake Lively. Friedman can't say that out loud, though, because it looks pretty bad to say that you oppose this defense of a policy that protects survivors. And that's exactly why he keeps saying the Wayfarer parties respect the work of the organizations, even as he continues to undermine their work. On that note, let's take a look at his second argument, that this amicus brief does not satisfy the conditions for one to be submitted and includes irrelevant arguments. Freedman explains in his opposition letter that an amicus brief should normally be allowed when a party is not represented competently or is not represented at all, when the amicus has an interest in some other case that may be affected by the decision in the present case, or when the amicus has unique information or perspective. That "or" is important, so I'm setting aside the first condition because I agree that nobody is claiming Lively's lawyers are incompetent. However, the second two conditions are satisfied. First, the amici obviously have an interest in other cases that may be affected by the decision to accept or deny Lively's motion to dismiss. As they state in the amicus brief, a decision to deny would undermine the framework of AB 933, the law they drafted to support victims who are afraid to speak about their experiences of sexual violence or discrimination for fear of retaliation via defamation lawsuit. To say that Freedman's argument claiming that AB 933 is unconstitutional would not have an effect on cases relevant to the legal professionals who helped draft this law is nonsensical. Second, the amici do have a unique perspective on this case as experts on AB 933. Again, they had a hand in drafting it, and as advocates for survivors. Since Blake Lively is someone claiming to be one of those survivors, they can clarify points unique to her position. That's why they spent a significant portion of the brief explaining survivor-abuser dynamics, including Darvo. Though Freedman claims that the motion is also improper because it raises issues Lively did not mention in her original motion to dismiss, specifically related to abuse of the discovery process, he is actually building support for the argument that the organizations who submitted the brief do offer unique information and a unique perspective. That's because Freedman made it very difficult for Blake Lively to raise any motion for a stay of discovery in the weeks leading up to the lawsuits being filed. He constantly talked about how his side would reveal all the receipts, which implied that anything less would be seen as deception. This is one of those strategies to attack the victim's credibility, the A in Darvo. It would have made it difficult for her to mention her concerns regarding his abuse of discovery, especially with so many eyes on this case. Speaking in the interests of victims who are subjected to abuse of the discovery process, the amici were able to bring up this unique point that Lively herself was not able to. Finally, we can move on to where Freedman says that the brief violates the timing guidelines. But he acknowledges that the federal rules of civil procedure do not address the submission of amicus briefs. And it's only his desire that this court enforces a rule from the appellate procedure. This is not an argument, it is a request. Basically, there is no timeline on amicus briefs for this case, and he is only trying to persuade the court to enforce such a timeline because it serves his purposes. Don't be fooled by this. Last time I asked you to consider, what does it mean to support a man fighting against a law intended to protect all victims? Now I want to ask another question. Why do you think Bryan Freedman is so eager to oppose this amicus brief, even though the judge is under no obligation to take its arguments into consideration? Could it be because it has a point? Thanks for watching all the way through if you did. If you found this video helpful, that's all I want. It might be a bit late to say this, but my previous video went over the initial amicus brief, so if you still need clarification, you can check that out. I also have a playlist of other videos about this case, and many thanks to the people at Baldoni Files for clarifying the difference between civil procedure and appellate procedure. Bye-bye!